Supreme Court of India Vashist Narayan Kumar versus the State of Bihar and others decided on January 2, 2024 INSC. Two facts of the case. Vashist Narayan Kumar, the appellant, and had applied for the post of police constable under the reserved category and cleared the written examination, and the physical eligibility test final results reflected him as having failed. The reason was that, while in the application form uploaded online, his date of birth was shown as December 8, 1997, in the school mark sheet, his date of birth was reflected as December 18, 1997. He filed writ petition and a letters patent appeal before the High Court. Both were dismissed. Findings of the court. Admittedly, the appellant derived no advantage, as even if either of the dates were taken, he was eligible. The error also had no bearing on the selection, and the appellant himself, being oblivious of the error, produced the educational certificates which reflected his correct date of birth. The facts are undisputed. The appellant's application uploaded from the cybercafe did mention the date of birth as December 8, 1997, while his date of birth as recorded in the educational certificate was December 18, 1997. It is also undisputed that it is the appellant who produced the educational certificates. He was oblivious of the error that had crept into his application form. It is also undisputed that the advertisement had all the clauses setting out that in case the information given by the candidates is wrong or misleading, the application form was to be rejected and necessary criminal action was also to be taken. The appellant has participated in the selection process and cleared all the stages successfully. The error in the application is trivial, which did not play any part in the selection process. The state was not justified in making a mountain out of this molehill. Perhaps the rarefied atmosphere of the cybercafe got the better of the appellant. He omitted to notice the error and even failed to avail the corrective mechanism offered. It is a trivial error which appears to be a genuine and bona fide mistake. It will be unjust to penalize the appellant for the same. We are inclined to set aside the cancellation. We set aside the judgment. Appellant be considered, and necessary appointment letter issued. The appeal is allowed.